Good afternoon and welcome. My name is Libby Benton and I serve as Senior Counsel at the Center for Community Progress. Community Progress is excited to co-host this webinar with the National Consumer Law Center focused on the Supreme Court's recent decision in Tyler v. Hennepin County. A few housekeeping issues before we get started. This webinar is going to be recorded, and the recording and the slides from the presentations will be posted on both organizations' websites. We have a lot to cover today, but we are going to reserve some time for questions at the end. So we really encourage you to put any questions you might have during the presentation into the comments, and we will try to get to them at the end. If we don't have time to get to your question today, please feel free to reach out to either organization. We're happy to chat with you about these issues. Next slide, please. So here's a brief overview of what we're going to cover today. We're going to start by talking about providing an overview of the case and talk about some of the questions it leaves unanswered and the need and the changes that some states, certainly not all, will need to make as a result of the decision. Then we're going to talk a little bit more broadly about property tax foreclosure and the opportunity that the Tyler case presents for all local and state governments to take a look at their property tax foreclosure systems and make reforms aimed at not just addressing the issues raised by the case, but reforms that can help prevent foreclosures and keep people in their homes, and also ensure that local governments can use their property tax foreclosure systems to address vacant, abandoned, and deteriorated properties, including to help reduce the harms caused by these properties and to return these properties to productive use. So with that, I'm going to turn things over to my colleague, Matt Kreis.
My name is Matt. I serve as the General Counsel with the Center for Community Progress, and really excited that we get to present on some of the impacts of this very important case, Supreme Court case. It really impacts a lot of our partners and communities across the country dealing with vacancy and abandonment. And I'm excited we get to speak on in partnership with our folks at NCLC. I've been with the organization for about 8 years and serve the organization in a couple of capacities, both in-house and as far as helping out our technical assistance teams across the country. I've also been able to work for the city of Chicago for about 10 years before I came here, helping advise a range of different city departments on issues related to vacant and abandoned properties. Next slide, please. What I'm going to do very quickly is Libby teed this up and said we're going to talk about reform, right? And that we desperately need to be thinking about what's going to be reformed, but what is causing all of this, right? And to do that, I'm going to give just a quick overview of what tax foreclosure is and what we mean when we talk about tax foreclosure in this context. I'll give a quick description of the case, an overview of the case, what happened, what are some of the key facts. And again, at a very high level, I urge you all to take what you learn here and go back and consult with your local counsels and lawyers at home and say, what else do we need to know? What are we missing for your own jurisdictions? And then also, I'm going to start the conversation by starting to look at a couple of key questions that the case didn't actually answer that are going to be really important to try to figure out so that states and counties and other foreclosing governmental units can keep in mind as they begin to design, do we need reform? And if so, what does that look like? Next slide, please. So as we are talking about reform, and this kind of is, we're putting this at the front, I'm going to give you the case overview, going to give you a little bit about tax foreclosure here. But when we at Community Progress talk about it, I want to make sure that we understand that what drives a lot of what we do in our work with communities is equity should be at the center of what we do. And equity in terms of fairness, in terms of racial equity, and all those kinds of ways that you could possibly mean that word. Our goal from reform, should your state have to reform, is to keep people in their homes first and foremost. I'm really excited to hear some of the perspectives of NCLC on that one today. And then second of all, we should be able to leverage this system to address the VAD next door. That's a term we use to describe vacant, abandoned, and deteriorated properties at the Center for Community Progress here. So as we are going through all of these descriptions, keep in mind that when we start talking about specific reforms, our thought is that largely we want them to sort of fall under one of these two buckets going forward. Next slide, please. All right, so let's start talking about property tax foreclosure, which I am sure everybody is excited to talk about. And the first thing that I want to do is really just discuss a couple of key terms. I'm going to use the term property tax foreclosure to talk about when it's either a judicial or a non-judicial process, but it's used to extinguish the current owners or former owners or interested parties' rights to that property on which those property taxes haven't been paid for usually many years. I'm going to use the term foreclosure sale, also known as a public sale, to refer to what happens at one of the things that could happen at the end of that process. At the end of the foreclosure, there might be a public auction where there is a minimum bid for the property, which is the total amount of the tax debt, interest, penalties, that kind of stuff. And the winning bidder usually would pay the most above the minimum. I'm also going to use the term, and I think several of us will, of strict foreclosure, where the local government is trying to foreclose these taxes. Instead of a foreclosure sale at the end, the foreclosing local government, or in some cases, the tax lien or tax certificate holder, takes direct title to the property at the end of the foreclosure. And it's these states that are going to need to be paying probably a lot more attention to the Tyler decision from the U.S. Supreme Court than others. I'm going to use the term redemption rights. What does that mean? It means that up until that interest, that former owner's right to the property is extinguished, they have the right to be able to redeem the property, meaning they have the right to be able to pay back all of the unpaid amounts and prevent the property from continuing to go down that path. I'm reintroducing the word equity from the previous slide. This is really important, and the Supreme Court uses the term equity in the Tyler case to refer to home equity or financial value in the property. It's a really important term. That's a really important way that it's used. I just want to tee this term up because we talk about it in a few different ways, both in terms of fairness and all of those reasons, and then also in that financial value. So just be aware, we'll try to signal when we're using it for one purpose or the other within this webinar. And then finally, surplus. Any excess value in tax foreclosed property that exceeds the total amount of the taxes or debt owed. So what does that mean? That basically means that, if you owed $10,000 in taxes and penalties and fees, but the property was worth or could be worth or would sell for $40,000, potentially there's $30,000 in surplus. Next slide. Great. Just want to tee up, we will not be able to have the time to go through how many different systems there are, but folks listening to this webinar should be aware that tax foreclosure looks different in every state. There are 50 states. There are several different mechanisms to be able to foreclose on unpaid taxes in all of those states. And there's probably 250 different systems. What we try to do is really boil that down to a couple of key ideas. Most systems allow for either the sale of the property at the end of the foreclosure process, or they enforce unpaid taxes by selling the debt in the form of a tax lien or a tax certificate to a private investor who will then, at the end of after buying the tax lien, the owner will have more time to redeem. And then if they are unable to do so, then there's a separate or another foreclosure event. Now, that's very general, very high level. We like to put that as this: either you can sell the dirt or you can sell the debt. And many jurisdictions allow for the sale of one, the other, or both. Next slide, please. All right, finally, we've done all of this kind of covering our bases, and now we're going to get to talk very quickly about what the Supreme Court decided in Tyler versus Hennepin County. Right, and I'll take you through just a quick statement of the facts. So 94-year-old Geraldine Tyler stopped paying taxes on her condominium after moving to an assisted living facility. Hennepin County, Minnesota repeatedly warned Ms. Tyler that she could lose her property and offered payment plans and resources to assist her. The property also had unresolved liens in the form of a mortgage and HOA fees. After more than 5 years of not paying property taxes, during which she accrued, I think, about $15,000 in unpaid taxes, interest, and fees, the county foreclosed on and took possession of the property. They sold it at an auction about 15 months later for $40,000. Now, the county retained the excess $25,000 from the sale. The Supreme Court stepped in and ruled that by allowing the county to keep the surplus from the sale, Ms. Tyler had stated a claims for a takings case for a violation of the Takings Clause of the Fifth Amendment of the United States Constitution. All right, so that is a very high level of some of the key facts. What is one of the key holdings from it? That's the next slide. Now, this is one of our key takeaways. There are a lot of different ways of saying this that other lawyers are putting out there, but something I want this group to take away is that foreclosing local governments can continue to utilize tax foreclosure to collect private debts, but they cannot retain any value that exceeds the total amount of the tax lien being foreclosed. One of the things the Supreme Court said very clearly is that local governments can take what they are owed, but no more. And this is really important, particularly for those states like Minnesota that historically, and roughly a dozen other states that have some measure of being able to do so to keep the property and keep any excess value in it. So that's a key takeaway. There's a whole lot of other things the court said. I just want to highlight that as one of those key takeaways that'll help in this discussion. Next slide, please. Now, there's a lot of things that we don't know. There's some things we do. Liability for taxing entities, likely counties, in some cases municipalities, will likely apply both retroactively and prospectively. There may be people, we don't know how far back it's going to go. And quite honestly, this presentation isn't about that retroactive liability. It's a huge question, and I don't want to diminish that that's an important point for people to remember. But for the purposes of this conversation, we're going to be looking prospectively, and that is, what can people do in the future to assess what about their system needs to be more compliant with Tyler? And quite honestly, how can we be better at keeping people in their homes and also addressing the vacant properties next door? Next slide. But there are, again, as we said, lots of key questions. I'm going to tee up just a couple of these here, and then my colleague John Rayo from NCLC is going to continue with some excellent thoughts for everybody to keep in mind too. So what don't we know? Next. Some of the key factors that we need to consider here, the questions that we need to start thinking about is, so we have this law now that says things are a taking, but when does that taking take place? Right? Supreme Court didn't really answer that. In fact, we know that the county took title to the property at one point and then didn't sell the property or generate any excess proceeds until 15 months later. So there's a question about when that taking actually occurred. Our organization has been arguing that it's probably the wisest to be thinking about that question in terms of as soon as the property either transfers hands or the former owner's rights to redeem or any other interested parties' rights to redeem are extinguished and they can no longer redeem, is about the point when we think the taking of the excess value occurred. All right, and remember, it's a taking of that extra equity or the excess value in the property, not necessarily of the property itself. It's the equity in the property. When does it take place? On or as close to that event as possible. And so it's wise to consider when we're going to also talk about valuation, which is the next question that the Supreme Court didn't really answer. And how can local governments determine whether a surplus exists? And this is a big question. What the Supreme Court talked about in this case were a number of things, and we don't really have a clear and total answer. What we know is that in many jurisdictions, particularly you can look to mortgage foreclosures, right? Where there is at the end of the process, a public sale of the property. We talked about that, the foreclosure sale or public sale. Supreme Court seemed to suggest in this case that having a public sale at which the market comes in and bids on the value of the property seems to be an acceptable way for local governments to establish that value. That said, the Supreme Court wasn't clear. They didn't say you couldn't have an appraisal at that point in time or anything else. But what is clear, and there's a subsequent decision out of the Sixth Circuit that said that public sales are actually an okay way of generating a value for the purposes of determining whether some surplus exists. Now, I'm going to stop there, and I'm going to turn this over to my colleague, John Rayo.
Counsel at the National Consumer Law Center. So as Matt mentioned, when you're thinking about factors related to the Tyler decision, I'm going to be presenting this from the perspective of whether you're evaluating whether the current law in the state presents problems from a constitutional perspective, whether things need to be changed to make it satisfy the constitutional requirements, and also factors to consider as you're looking forward to making changes in the law. So as Matt mentioned, if there's not a surplus generated in the process, then there can be a problem. And when we talk about surplus, what does that mean? And I think it would mean at a minimum that there be some point in time in the tax foreclosure process where there is a high bid auction of the property itself. So using Matt's terminology, of the dirt, right? The property, not a certificate, not a lien in the property, but the actual property itself. And when I say high bid auction, I'm not saying that this is necessarily going to be a process that's going to generate something that is absolutely, fair market value. Forced sales, foreclosure sales always will produce a price that's less than that, well, almost always. But at least there's the potential for there to be a sale where there is competitive bidding. One of the things that I think is really unique about the tax foreclosure process is that there's often a redemption period, and sometimes it's a long redemption period. And the question is, when does this high bid, if there is a high bid auction, when does it occur? If it's so early in the process, and then it's followed by a long redemption period, it's not clear to me that that would generate a real high bid that we would normally think would occur at like a mortgage foreclosure sale. And in fact, there's some examples of this. I'm aware of one state where there is a high bid auction of the property itself, but there's followed by a long redemption period. And in that state, some have looked at the median sale prices at tax sales, and in that state it's $7,000, which is really close to what just the taxes that are owed. And the median home sale price in that state is around $300,000. So they're not even close. And I think the reason for that is that the long redemption period does suppress bidding at the sale. And maybe that's something that's comes with the tradition of tax sales. I'm not sure, but it's certainly a factor that I think we need to consider. Is there a high bid sale only if the prior auctions don't yield a minimum bid? So there could be sales where the state may say, oh yes, we have a high bid sale, but it really doesn't happen very often because it only occurs if the earlier sales didn't receive a minimum bid. Is there something that comes close to generating a competitive bidding? Are there things that are done to satisfy that requirement? Is the sale conducted in a regularly conducted manner? Is there advertisement for it? Is there a state official oversees the sale? These are the kind of things that I think we would also want to know. And then there are a few states that sell tax liens or deeds in a bulk sale, and yes, it is to a highest bidder, but if it's in a bulk sale, how do you know what the bid was for the actual property if you're trying to determine a surplus on a property by property basis? So those are some concerns there. Next slide. Another factor is whether the state currently may provide for the right to a surplus, or a state may be considering, if there's a Tyler problem now, creating a right to a surplus. But does it come with limitations that would prevent it from really being accessed, or affected in a way that may have constitutional issues? Illinois is an example of, they've created an indemnity fund to provide homeowners to access funds that would approximate a surplus, but it is capped at an amount. And in order to get above that amount, you have to show that you are not negligent in failing to pay the taxes. Maybe that's okay, but again, that raises some questions. Alabama requires that the owner first redeem the property before they can recover the surplus. I'm not sure that's going to work. That seems to me like that's going to be a problem. If the owner could redeem, then they could avoid the sale to begin with. Next slide. The other major issue that's left open by the case is a lot of states may be thinking, well, there's this older Supreme Court case, the Nelson case, and this was actually argued in Tyler, which says that at least if there's some opportunity to ask for a sale, to request a sale, that's good enough, and we don't have a takings clause potential problem. That may be true. We just don't know. And can states really rely upon Nelson? It's important that in the Tyler decision, the current Supreme Court in that decision, they didn't really reaffirm the Tyler decision. It was certainly raised as a defense by Hennepin County that yes, there is a way potentially to get the surplus. Ms. Tyler she had 3-year redemption period. She could have sold the property on her own. The Supreme Court said that it didn't reaffirm the decision. It just said it distinguished it, and that's the most we have at this point. And they distinguished it by saying that Minnesota provided no way for Ms. Tyler to access her surplus or her equity once the property had been taken from her. And there was another statement that the court made in the Tyler decision by saying that in response to the Hennepin County's argument that, well, she could have just sold it on her own, the court said requiring Ms. Tyler to sell her property to avoid a taking is not the same as providing her an opportunity to recover the excess value once it's been taken from her. So that's sort of suggesting that maybe requesting a sale very early on in the process may not be sufficient. That if there is a request, if the owner has to request a sale, maybe it has to be after there's been a transfer of the property or close in time to that, not maybe months or years before the actual final transfer of the property. And if there is this right to request a sale and for surplus, certainly the state, I think, will need to provide adequate notice of that right and make the process easy. I mean, I know some states are thinking about changing their laws to have this request opportunity, but in order to do that, you have to bring a court action to request the sale. And we have to remember that for a lot of, for the properties that actually go to tax sale and are lost at a foreclosure, there's often a good reason why the homeowner hasn't redeemed, either because they don't have the financial resources to do it, or because they may be suffering from some kind of mental impairment, dementia. And so requiring them to bring a court action to even access this surplus, I do question whether that will satisfy the constitutional requirement. So another thing to consider. Next slide. And finally, there's been discussion about whether the Tyler decision would have any impact in the good number of states where the property, either the property or a lien or certificate is sold to a private buyer, and then that buyer has a right later in the process after the redemption period to foreclose the right of redemption and to become the outright owner of the property to accomplish the final taking of the property. And some have thought, well, the Tyler decision really was a strict foreclosure. It was just the state taking, or the local government taking the property. Maybe it doesn't apply when there's a private buyer. And my personal view on this is that it absolutely does apply. Just the fact that there's a private buyer doesn't change the constitutional question of, does the owner have an opportunity to recover their surplus? The private buyer in that situation is really acting under color of state law, and they are performing a public function in the sense that they are completing the tax foreclosure process, which was started by the governmental entity. The Colorado and Massachusetts Attorney Generals have both issued opinions, and both of those states do have private buyers, and both have issued opinions saying that they do think that their system, their schemes, statutory schemes are unconstitutional. And just yesterday, an appellate division of the court in New Jersey held that in New Jersey, which does also have private buyers, that there is a constitutional problem there in light of the Tyler decision. So with that, I'm going to turn it over to my colleague, Odette Williamson.
Odette Williamson from the National Consumer Law Center, and I will take you through a discussion of some of the populations that are most disparately impacted by tax foreclosure. Can I have the next slide, please? And the next slide. So we'll start with a 2020 survey of consumers who reached out to a Baltimore tax sale prevention clinic in 2020. It gives us a really nice snapshot of the populations that are most at risk. And as you can imagine, the first one are older adults, especially those who have paid off their mortgage and no longer have escrow accounts. People with disabilities, also communities of color. And in fact, in this community, it was heavily Black. So Black homeowners, of course, are at risk of property tax foreclosure. And most importantly, in all of these instances are lower income individuals. And you can see here nearly 3/4 reported annual household incomes of less than $30,000. Next slide, please. So what are the factors that contribute to those numbers? Well, let's drill down on older adults, for example. Older adults face a number of hurdles, and there was another survey that looked at some of the factors that contribute to them facing either unaffordable taxes or tax liens. And some are really obvious. For them, the taxes are too high, and if there is the death of a spouse, a decrease in the household income, or if there's an increase in expenses, and now we have, a rise in inflation, the taxes become quickly unaffordable and they fall behind. In addition, there's just not enough property tax relief programs, not enough exemptions, not enough repayment plans and other options to assist lower income older adults. And if they do fall behind, then the interest, the penalties, and other fees that are added can be significant, and they are unable to pay that off in a lump sum. As John mentioned, there are issues with dementia and other cognitive impairment, and that could lead to difficulty remembering to apply for all those property tax relief programs if they do indeed exist. Not to be underestimated is the lack of technology or lack of access to broadband. And in fact, most low-income people, including older adults, they do access the internet through their phone. So there's just a lack of access to technology that will help them in applying for all those property tax relief programs. Next slide, please. Now, for communities of color, there are other factors that come into play. There's research that has been done over and over again that says homeowners of color are more likely to face property tax foreclosure. There are research and studies that have mapped the high rates of delinquency and tax foreclosure in DC, Baltimore, Cleveland, Chicago, New York, in a number of those marquee cities. And what we know is that when homeowners lose their home to foreclosure, the property is often purchased by investors. And the purchase of the tax liens by investors leads to gentrification in many, many of these communities, rapid gentrification at that. And that can push out lower income residents and the elderly from what was once affordable communities, affordable neighborhoods. On the other side of the ledger, we have some communities or some neighborhoods where property values are further depressed, and there is an increase in blight, including in vacant and abandoned properties. Next slide, please. Now, there are a number of reasons that we see why these communities are particularly vulnerable and why they lose their home to tax foreclosure. But what we know is that the loss of the home to tax foreclosure also increases an already large but persistent racial homeownership gap. And in fact, historically, the gap between homeownership rates between white and Black households, for example, has been about 27 to 30 points. For other households, Hispanic and Asian households, it's been less, but there's always been a persistent gap. And the rate of property tax foreclosure is feeding into this actual homeownership gap. Next slide, please. We have to also look at historical discrimination in the housing market. And what we know is that there are a number of laws and policies that segregated public and private housing, either through redlining or lack of access to government-backed loans or exclusionary zoning or other racist policies that denied older generations of homeowners access to homeownership opportunities. And that is reflected in the homeownership rate today, which, for example, for Black households is 44% compared to white households of a rate of 72.7%. But there's another key reason why we focus on homeownership as a source of wealth, and that is because home equity, the value of the equity in that property, is the cornerstone of building wealth for many communities of color. Housing equity makes up 66% of the total net worth for Hispanic households, 56% of the total net worth for Black households, compared to 43% for white households. So that is a significant amount of wealth that is lost when there is tax foreclosure. And it drives the average household wealth today, which is about $24,000 for Black households, $36,000 for white households, compared to household wealth of $189,000 for white households. There are other factors as well. Next slide, please. Housing equity does not even compare to other wealth building tools and opportunities. And as you can see here, only about half of Black and Latino individuals have retirement accounts. Kind of the same factor plays into family-owned businesses, which is another way that we build wealth. Black and Hispanic families are half as likely to own a business and be able to benefit from that wealth building opportunities. And in terms of vehicle ownership, there's not such a great disparity in the ownership rates, but it is important because about 80% or so of folks in the United States actually need a car to get to work. So they need a car to get to work to get income to maintain their home ownership status. Next slide, please. Another factor that we are looking at is even if we have these communities, even if they're able to keep their homes, even if they don't lose their homes to foreclosure, the carrying costs are pretty high. They pay higher amounts in taxes disproportionately higher taxes relative to their home's value. And what we've seen is that some research have noted, one research, for example, noted that on average, Black households pay $390 per year, more per year in taxes compared to white households. And they also, this same research also looked at the carrying costs of the cost of maintaining that home ownership. And the costs involve not just paying property taxes, but the cost of financing that home, the mortgages that were involved. But this research concluded that nearly a quarter of the disparity in total home ownership costs for Black households as compared to white households is due to local property tax assessment. And that is higher for any other costs involved in maintaining the home. Now, for families living on the financial edge, higher property taxes combined with other property-related fees and costs increase the risk of foreclosure and displacement. Next slide, please. So what can we do? We know that high rates of property tax foreclosure really drain wealth and destabilizes communities of color. So it is imperative on us as government officials, as advocates, to look at strategies to maintain home ownership. And so governments have an obligation to affirmatively further fair housing, to look at overcoming patterns of segregation, promoting fair housing choices, and promoting inclusive communities. And one way that this can be done is really by taking aggressive measures to preserve existing housing, especially because existing housing is a key source of affordable housing now that we've seen the run-up in housing values currently. So we want to preserve that source of affordable housing. We want to reform the tax process to increase protections for consumers, to increase equity. And we want to decrease the role of investors in that process because we know that research has shown that that is very, very problematic. We want to pay particular attention to the reforms that are being put in place, including the inequities in the tax assessment and appeals process that researchers have identified as the reason that drives the disparities in the tax rates. And we also want to look at populations whose primary language is not English. And we want to make those notices and information readily accessible, especially for those communities in the language that are most commonly spoken in your city, municipality, or area, so that we have really democratized the information that is being provided to our homeowners so they have the best chance of saving their home. I'm going to turn it over right now to my colleague, Andrea Bob-Stark, who will drill down on some of these proposed reforms. Andrea?
Okay, let's start again. Hi there. Andrea Bob-Stark from the National Consumer Law Center. And I'm going to talk to you a little bit about some of the recommendations we have for preventing tax foreclosures, for not letting it get to the point where Ms. Tyler's home got, and to put into place some relief options that will prevent the tax foreclosures from happening in the first place. So next slide. So prevention, that is the key message here. We don't want it to get to a tax foreclosure sale. So how do we do that? A lot of states are going to be looking at their tax foreclosure laws right now because of the Tyler v. Hennepin case, and hopefully reforming some of those laws. So we hope to get our foot in the door, some of you to get your foot in the door to try and implement some of these preventative relief options as well. Next slide. And we have a 2-pager that outlines some of our basic recommendations. There's a link in this PowerPoint, and I do believe you'll be getting a copy of this. And you can take a look at that. I'm only going to address 1 or 2 of these because of our time limitations. So next slide. So the big one I want to talk about quickly is our property tax assessment. So There could be an entire webinar on property tax assessments and the issues with assessments, but I just want to point to a few facts. There are definitely inequities in the tax assessment systems in many municipalities and communities. There are irregular property tax assessments, which lead to disproportionate payments of taxes. We know that Black and Hispanic homeowners are paid disproportionately higher taxes relative to their home's values, and off the side of the envelope calculation is we know that it's about 10 to 13% higher property tax that they pay each year, but it's roughly an additional $6.5 billion owed for property taxes each year, more than their white counterparts. Next slide. So this is just a demonstrative that I created. It's not based on any data, but it just, it kind of shows one way that taxes can become so disproportionate based on the lack of regular tax assessments in a community. So in some neighborhoods, the white communities' homes and the communities of color homes start out at a similar value, and they're paying a similar tax rate, similar tax amount. But over time, the homes in the white communities increase in value, and the homes in communities of color stay the same or decrease. And that's a whole other issue. But that does happen in some communities. But the taxes owed are the same. So the higher valued homes are paying the same taxes as the lower valued homes because there hasn't been a regular assessment. And that's just one way that these irregular tax assessments can harm communities of color and lower valued homeowners. Next slide. So what we recommend is implementing and improving oversight for assessments, having them done on a regular basis, whether that's every couple of years, every 5 years, but something less than every 10 years, and have them be accurate and based on industry standard techniques. There's a caution here of payment shock. So because property values have risen quite a bit in the last 5 years, if there hasn't been an assessment over an extended period of time, like 10 or 15 years, some communities 20 years before they do another assessment, there could be quite a payment shock for these lower valued homes where these homes are now worth quite a bit more than they were during the last assessment. So encouraging municipalities to implement that in an interval basis and not cause payment shock or cause this huge lump sum payment that will now be due by lower income, lower valued homes that will inevitably lead them to a tax foreclosure. Okay, next slide. Appeals are also a big issue with tax assessments. We know that Black homeowners are less likely to appeal their assessed values, and if they win, they are less likely to succeed at the appeal. So we recommend open, accessible appeals processes, including a very comprehensive notice of how to do this, when to do this, and how to access help in appealing an assessment. And just a very side, I've heard of entities who are going around and offering homeowners, for a fee, of course, to appeal their tax assessment for them, put together kind of a CMA and appeal it for them. I've heard they're not overly successful. So that's just a potential scam to be aware of that I heard at a conference recently. Next slide. So I'm just going to quickly go through a couple common sense recommendations, comprehensive notice in English and the most common languages spoken in the state of all the tax relief options that are available, information if there is going to be a tax sale, about the redemption period, and details about any other post-sale procedures. Next slide. Obviously, more generous exemptions is a great recommendation, but targeting them to older, disabled, or lower income households, and implementing what are called circuit breakers, which is kind of a cap on the amount of taxes that lower income households would have to pay. Next slide. And you could, I put Boston in here as an example of a progressive exemption tool where they just have a flat dollar amount of 35% of the average assessed home value in the city. And so in 2021, that was a flat dollar amount of about $295,000 as the exemption. And so obviously that helped lower income, lower valued homes quite a bit. Next slide. Payment plans, also very common sense, but a lot of municipalities do not allow payment plans, either for prepayment of taxes coming up or for when the homeowner falls behind. And it can be very difficult for somebody on a fixed income or living paycheck to paycheck to pay the lump sum taxes that are usually due twice a year or even once a year. When that lump sum comes due, it's very difficult. So encouraging municipalities potentially to partner with a third-party vendor to allow for prepayment of these taxes. Next slide. And then, oh, next slide. And then the redemption period, some states don't even have a redemption period. A redemption allows the homeowner to still reclaim the home after the property is sold at a tax foreclosure. And some have a very short window, and others charge exorbitant fees and penalties and interest to redeem, so it's unaffordable. And so next slide, the solution is really just having reasonable time periods to redeem. Again, notice of these periods, how to access them, and limiting the interest fees and penalties that accrue so that they are affordable, that they are a real accessible option for homeowners. Next slide. So I just want to talk very briefly about protecting heirs property. I know this is, again, a whole other webinar in itself, but next slide. Heirs property is family-owned property. When the deceased passes away, the descendants inherit the home. They may still be living in the home, but there is no will or the estate has not yet been probated. And so this makes it very difficult for these heirs to access any type of relief, but especially property tax relief. A lot of municipalities require what's called record title, or for the new owner to be on the deed. And without the estate being probated or without a will, a lot of times they're not on the deed. And so they can't access this relief and prove that they're the record title owner. So next slide. This is very harmful to heirs because the prior owner, who is now deceased, may have had an exemption and be paying a reduced rate of taxes. And now when this heir inherits the home, continues to pay that rate of taxes, but it may not be the tax exemption that the heir is entitled to, or the heir has not known that they need to access this tax exemption yet. And so they're paying the reduced amount and they get further and further behind on their taxes. So next slide. We encourage you to include heirs in your advocacy work and ensure that those who are residing on the home and who would otherwise be eligible for tax relief have an opportunity to access that, whether it's what's called an affidavit of heirship, which allows an heir to access and prove title without being on the deed, or some other type of avenue to prove that they own this property without having to probate the estate, which can be very expensive and time consuming, and then allowing retroactive relief for those heirs who don't get on top of this right away, understandably, because they've just lost a loved one, but allowing that relief to be retroactive. Next slide. And here are some resources for you on this issue. And next slide, we'll have our manual, which I encourage all of you practicing in this area to access our manual. It has a new chapter. It has a chapter on preventing property tax foreclosure in the home foreclosures manual. And next slide provides some contact information. We have an Equal Justice Works fellow working on this issue. So I'd encourage you to reach out if you have issues or questions or want some policy support. Okay. And now I'm going to pass it to Libby Benton.
Thanks so much, Andrea. And I'm going to be talking about policies, reforms that can help local governments better address vacant, abandoned, and deteriorated properties. And before I dive in, we just want to say that if you're a community thinking about policies to address vacant, abandoned, and deteriorated properties, the preventing foreclosures is also a critical piece of preventing vacancy. So really ask yourselves, do you have those exemptions, those payment plans that Andrea talked about in place to prevent properties from becoming vacant to begin with? Next slide, please. So just to take a second to say, what are we talking about here? Vacant, abandoned, deteriorated properties are properties that are causing harms to neighbors and neighborhoods. They hurt the public health and well-being, drive down surrounding property values, and they cause increased costs to local governments because the owners of these properties, they're often out-of-state LLCs or people who have completely walked away. And so no one is maintaining the properties. No one is often paying property taxes. And so the big issue here and how it relates to property tax foreclosure is that the most effective way to address these properties when they've been abandoned is to transfer them to new owners who are going to take responsibility, start paying taxes. Next slide, please. The real problem is that in many states, their property tax foreclosure systems makes this kind of transfer to move these properties into more responsible ownership very difficult. Oftentimes, properties get stuck in limbo if the title is held by an owner who's walked away, but the lien is held by a property tax investor who's not interested in the property or maintaining it. They're stuck in a legal limbo. And oftentimes, the property tax foreclosure system can make things worse because constitutionally adequate notice isn't provided. So a property that's been foreclosed doesn't have clear title, and the new owner's not able to get title insurance without doing a costly and sometimes time-consuming quiet title action. And these properties are stuck, and there's really no way for the local government to gain control to try to move these properties on. So next slide. But the good news is that there are some solutions and that there are changes to the property tax foreclosure systems that states and local governments across the country have implemented and have been using for decades that can help make this better. So we're running short on time, but I'm just going to highlight 4 main types of reforms for you all to consider. And so one is to create a shorter process for bad properties. Time is the enemy of bad properties and can make the difference between a property that can be rehabbed or needs to be demolished. So allowing local governments to start the foreclosure process sooner and having expedited processes. Next slide. The second reform that I think we have all talked about is selling the dirt, selling the property itself rather than selling the lien. When you sell a property, it's more like the communities we've worked with have found that attracts a broader audience of purchasers and is more likely to result in the property being sold to a responsible owner. Next slide, please. The next is ensuring that in the foreclosure process, the foreclosing government is providing constitutionally adequate notice. That usually means doing a title search, sending notice in various forms to all interested parties and owners identified, and then also having a judicial process that can be a check to make sure that's happening. And the reason why that's important is if you have those procedures in place, it's more likely that all of the interests have been extinguished by the foreclosure sale, which means a title insurer is more likely to be willing to issue a policy, which is often needed to get financing to acquire, repair, or rehab a property. Next slide, please. And finally, if a property is offered at a foreclosure sale, and there are no bids for the minimum bid, indicating that there's really no market. The private market is passing over these properties. Then we really recommend a mechanism that allows these properties to be transferred to a land bank or to a local government. And then the local government or land bank can be in a position to remove any additional barriers, clear title, do demolition if necessary, combine parcels, and then they can also be in a position to direct those properties to the uses that meet community needs, selling side lots to neighbors, working to get properties in the hands of first-time home buyers, directing properties to affordable home buyers, not just to the highest bidder. Next slide, please. I've only been able to talk about these topics briefly, but please check out these 2 resources we have that really dive into all of these issues in much more detail. And next slide. And if you're really interested in learning more about vacant property, come to our conference this coming October in St. Louis. And next slide. And please do not hesitate to reach out to me or Matt. We're always more than happy to talk about these issues in more detail. And let me just check we have 5 minutes remaining for questions. So please feel free to put any questions that you might have in the comment box, and we'll see what we are able to address. It looks like I have a question here for Matt. The question is from Sarah. If you could talk a bit about what impacts the Tyler case has on land banks, for certain land banks.
Sarah, that is an excellent question. There's a couple of different ways of looking at it. And the first thing too is that there's a whole lot about this decision that we still don't know, right? And so that's why we kind of highlight those as some unanswered questions earlier in the process. But what I would say is that at the very least, we do know that the county will likely be on the hook. So if there's a Tyler claim, somebody's claiming that their property was transferred and it was worth more than the amount of unpaid taxes and other interest or penalties or other things that were included in that judgment amount. So the tax lien judgment, right? To the extent that the county chooses to transfer that property to satisfy that to the land bank, it seems likely that the county or the public entity would still potentially be on the hook. But again, I think that we're not 100% sure how that would extend to the land bank. It's possible that a court would look at the land bank's future sale as something that would generate a surplus because of the government ownership. But we really don't honestly know here, Sarah, and I don't want to speak as though I have the answer completely. Our suspicion is that it's probably definitely with the county, but it's certainly something. This is how the public sale, for example, could help. As Libby outlined, a possible process is if there is a public sale and then it goes to the land bank. I think what we are talking about here, though, is money, and I want to illustrate that, right? And so there are certain projects where land banks are wary, and rightly so, of the speculative market, particularly for vacant and abandoned properties that come through this process. And so, we're aware of that, but certainly want to raise that, it's not completely clear here, but we're not really talking about the title issues. We're talking about how much it's going to cost at some point in time. So folks need to assess that risk and think about that in terms of where their system comes into play. Hope that was helpful.
Great. Thank you so much, Matt. And thank you to all of today's presenters and everyone who was able to join us. We'll be sending out the slides and the recordings, and both will be posted on the websites of both organizations as well. So thank you again, and please do not hesitate to reach out if you have any additional questions. Thanks.